I'm going to introduce Representative Doug Bankson here. If you would, to go ahead and introduce, you should have a copy of the bill in front of you, the model legislation, and I'll turn it over to Representative Bankson.
All right, thank you, Senator. And it's a privilege to present this on behalf of Senator Mark Abraham from Louisiana, who was going to be doing this, but he wasn't able to be here. So I want to just start by saying this it checks all three boxes that you mentioned from the SCOTUS 52 decision. So this bill is really very succinct. There's 5 sections to it. First of all, of course, the title, you put your state name in there, State Released Time Education Act. But the definition is released time course means a course in religious instruction taught by an independent sponsoring entity in which a student is excused from school to attend. And school district means you would cite your law, your state definition there. But note it says this should not apply to private schools. And I know sometimes there's concerns with private schools being involved that will this affect them? But this, of course, protects them. Section 3 gets into the meat of it here. Each school district shall adopt a policy that excuses any student under its jurisdiction from school to attend a released time course for at least 1 hour per week, but not more than 5 hours per week. The policy shall include basically 7 parts here: the student, parent, or legal guardian written consent. Second, the entity sponsoring the released time course maintains attendance records, and so they're available to the school through them. Number 3, the transportation to and from, including students with disabilities, is the complete responsibility of the sponsoring entity, parent, guardian, or student. So it doesn't fall upon the public school, upon their budget to handle that. Number 4, the sponsoring entity makes provisions for and assumes liability for the student while under the control of the sponsoring entity. Next page. No school district funds other than de minimis administrative costs are expended in providing the release time course. So even in states where they're concerned or they're trying the may rather than the shall, we need to get it across that line and be that vanguard to protect the rights that they have. And this, of course, is the model legislation that NACL is putting forward. Number 6, release time courses are not to be held on school property unless permitted under a neutral policy of equal access, opening school property for use by community groups. So it leaves a little bit of an open door there rather than it cannot. Basically, if they have a policy that allows other groups, they can incorporate it there as well. And finally, number 7, the student assumes responsibility for any missed schoolwork. So this isn't an excuse to get out of other classes. Notwithstanding any law to the contrary, any period for which a student is excused to attend a release time course shall be considered as the student attending the school from which the student is excused for the purpose of determining school funding and satisfying attendance requirements. So some funding obviously depends upon the number of students being there. This will not hurt the school's funding. Sometimes that's an objection they try and bring up. And nothing in this act shall be interpreted to deny a release time course or the sponsoring entity equal access to funds, benefits, or services that the local school system may provide or make available to community groups or other independent entities. Let's go on to section 4. Again here, a school district shall adopt a policy that awards academic credit for the completion of a release time course and recognizes the credits as an independently accredited provider of release time courses. So basically, this must be treated as any other elective, the same way they would treat a secular elective. They have to treat this on the same basis. And B goes further in determining how much credit to award for a completion of such course. The school district shall evaluate the course based on purely secular criteria that are substantially to the same criteria used to evaluate similar courses for the purpose of determining how much credit the course is awarded there. The decision to award credit for the release time course shall be neutral to and shall not involve any test for religious content or denominational affiliation. So there's no fear that the school then begin to decide and determine what type of denominational structure is there. They have to give it the same weight as they would any other secular course. Under C there, for the purpose of this section, secular criteria may include, but are not limited to, the following: the number of hours of classroom instruction time, the review of the course syllabus, number 3, the methods of assessment used in the course, and finally, The qualifications of the course instructor, which shall be similar to qualifications of other teachers within the district. And finally, number 5, a right of action. So basically, any person or organization aggrieved by a violation of this act, in other words, the school saying, no, we're not going to allow you. No, you shall. And that's what we want to get across here. Anyone who is aggrieved by this, they have the right of action basically for the violation and seek appropriate relief, including but not limited to injunctive relief, monetary damages, reasonable attorney's fees, and court costs. This is both for the organization or the individual. And that's the whole of the bill there, and such a tremendous presentation. I think the bottom line is the return on investment. We always talk about that in business.